Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all. So last night, I believe it was last night or the night before, we kind of talked about Jay-Z's declaration that was submitted with the opposition to Tony Buzbee's motion to strike. There was a lot of confusion out there. People automatically believed that Jay-Z filed a lawsuit right after the Jane Doe case was voluntarily dismissed, and that wasn't the case. But if you guys have been following me, you pretty much know the timeline in which everything happened. So he sent the John Doe demand letters to and when I say he, Buzbee. So Buzbee drafted and sent over the Jane Doe, John Doe letters to Jay Z. He gave Jay Z until November 19th, 2024 to respond. Jay Z filed a lawsuit in California under the pseudonym John Doe on November 18th, the day before the response to the Jane Doe and John Doe demand letters were due. This is the lawsuit that Jay-Z pretty much claimed extortion. Then in December, Jay-Z amends the complaint to also add defamation. So this is an extortion and defamation lawsuit that was initially filed in November, and then it was amended in December to add the defamation claims. Now, what we have been reading or people have been putting out on the internet is the declaration that was sent with the opposition. So the opposition document wasn't available, and that's what we're going to go over to see as to why he's opposing to Buzbee's motion to strike. In addition to Jay Z's declaration that was submitted, an expert declaration was also submitted to or with the opposition. Now, in January, I want to say either late December or early January, Buzbee filed a motion to strike, and what he wanted to do is strike out some parts of Jay Z's amended complaint. And usually, when you file a motion to strike, that's usually a request to move like certain parts of the complaint from the record. And it could be information that's either irrelevant or redundant or insufficient or just plain out not facts. Okay. And so Tony Buzbee has moved to get parts of that amended complaint removed. Now, the reason why Jay Z ended up, like I said, filing suit was for extortion over the both of the demand letters and because of uh defamation. Okay. Now, let's tap right on into the opposition. So, this is Jay Z's. He is opposing part of his amended complaint being removed. So he's replying back to Busby and say, "Hey, I don't think that parts of my amended complaint should be stricken from the record, and here's why." And it shows here, filed concurrently with the declaration of Sean Carter and the declaration of Mary A. Baldwin. All right. So what everybody is reading is the declaration, and it tells you at the bottom what the document is. Not a lot of people are reading that. They're just like, oh, it's $100 million lawsuit. No, it's not. All right. So table of contents, to go over the background. So defendant publicly threatened criminal prosecution. Defendant privately threatened to expose Mr. Carter. And when Mr. Carter refused to be extorted, defendant defames him. So these are the issues. This is what went down. All right. And they have their arguments. So let's go ahead and tap right on into it. Ooh, they cited a lot of cases. Googly moo. All right. Intro. Plaintiff Sean Carter has filed well pleaded claims against defendants Anthony Buzbee and the Buzbee law firm for civil extortion, defamation, and intentional infliction of emotional distress. Oh, he added that into there too. Oh, yeah, he did. The amended complaint alleges that there is no dispute that right after Sean Combs was charged with drugging and raping men, women, and children who attended his parties, Busby launched a nationwide publicity campaign to attract Combs' victims as his clients. I don't know if people are listening to the language that this attorney is writing this pleading. He said that right after Sean Combs was charged, like there's no allegedly or anything of that nature. He's just blatantly saying it like they know. Anywho's, let's see. Busby claimed that other high-profile entertainers had participated in Combs' criminal acts and threatened to expose and pursue criminal proceedings against them. To that end, Busby sent demand letters to Mr. Carter on behalf of two individuals who claimed that Mr. Carter had participated in Combs' criminal enterprise. Busby threatened to publicly pursue Mr. Carter if he did not agree to provide something of substance to compensate his clients. The key issue raised by Busby's motion is whether he can wrap himself in California's litigation privilege by claiming that his public and private threats to Mr. Carter was lawful acts in the aid of potential litigation. He cannot. When Busby crossed the line, and what sets this case apart from most litigation threats, and the case on which he principally relies on Mullane and Singer, is that he not only threatened civil litigation against Mr. Carter if he did not pay his clients, but criminal proceedings and a public spectacle as well. That renders his conduct extortion as a matter of law and bars him from invoking the anti SLAPP statute. Busby's defense is that he threatened criminal proceedings only in his public statements and did not repeat them in his demand letters to Mr. Carter. And see, that's what we were saying when we was reading the declaration. Like, it doesn't show that he threatened criminal, activity in the demand letters, but he publicly stated it. So that's why I was like, I don't get what they're saying. So they're saying what he did was he in trying to intimidate him by speaking publicly, but then in demand letters, like when you get the demand letters, oh my gosh, he said that he was going to do this. Let me go ahead and pay. But the law draws no such distinction. Busby's statements must be taken in their entirety, and his demand letters to Mr. Carter must be read in context. The hold otherwise would reward clever extortionists. As to Mr. Carter's defamation claim, it admittedly concerns matters of First Amendment protected speech. But Mr. Carter's present evidence here sufficient to meet his prima facie burden on the elements of that claim, including constitutional malice. That is likewise the case on his claim for intentional infliction of emotional distress. Busby's assertion that there is nothing extreme and outrageous about his false public claims that Mr. Carter is a serial child rapist is erroneous and appalling. The court should deny the motion. Now, people, I want to bring your attention. We're on page 7. This was filed on February 10th. This opposition was filed on February 10th. Jane Doe's case was dismissed voluntarily on February 14th. Factual background. After Combs' September 2024 indictment, Mr. Buzbee made a public solicitation to represent anyone who claimed to be a victim of Combs. As part of the campaign, Buzbee publicly threatened criminal referrals against anyone else involved. Then, in the midst of this campaign, Buzbee sent private demand letters to Mr. Carter on behalf of two clients, threatening to create a public spectacle unless Mr. Carter paid them something of substance. In the context of Buzbee's public statements, these demands were extortion, extortionate. Let's see. Defendant publicly threatened criminal prosecutions. Throughout September and October 2024, Buzbee laid the groundwork for extortion demands. On September 27th, he boasted on Instagram that his law firm represented over 120 people who'd been abused by Combs and his cohorts, stating that many other individuals will be implicated. 2 days later, Buzbee announced a press conference relating to other alleged perpetrators of crimes, including rape, aside from Combs. At at that October 1st press conference, Busby escalated his threats of criminal prosecution, vowing to find the silent accomplices and expose the enablers. He stated that he intends to make his clients available to the authorities, specifically to the FBI. In October, Busby began to represent Jane Doe, for whom he would later file an action in New York, accusing Mr. Carter of rape. In public appearances, Busby intensified his threats of criminal prosecution. On October 2nd, on a podcast, he pled to ferret out all the people involved who facilitated Combs' misconduct and to hold them accountable in civil and criminal cases. The next day, in a broadcast interview, Busby restated, "I expect the indictment and the charges in the indictment will grow. I expect other people will be implicated." He warned that those close to Combs should be prosecuted and put underneath the jail, and that they be criminally charged or even civilly sued. People should know. On October 7th, on the Sean Atwood podcast, Buzbee reiterated his threat of criminal prosecution. He foreshadowed that there are going to be people named in cases that are going to raise some eyebrows. On October 20th, Buzbee filed the New York action. Buzbee accused Combs and unnamed celebrity A of raping Jane Doe at the party where she was 13. Buzbee did not disclose the person's name. All right. Based on everything that he stated publicly, he didn't put any names on it. He didn't say Jay-Z or Sean Carter. He just said people that were close to Combs. So on that side, I don't see how you can relate what he said to the demand letter and come out with the conclusion that he was either trying to extort you or simply stating that he was trying to intimidate you in a way, if that makes sense. I don't see that connection here. Like, even though he said it publicly, he did not put any names. He just stated that anybody close to him will also be implicated. Now, Jay-Z, your attorney, came out and said that you and Sean Combs aren't friends, right? So if you guys aren't friends and you're just business associates, and you weren't close, then why do you feel as if he was speaking to you at the public conferences? Hmm. That should get your wheels spinning. On November 5th, okay, so B says the defendants privately threatened to expose Mr. Carter. All right, so now this is in private. Let's see what it says. On November 5th, defendants privately sent the extortion demands to Mr. Carter on behalf of two clients, Jane Doe and John Doe. The letters accused him of raping both individuals when they were minors. The Jane Doe extortion demand made clear that Mr. Carter supposedly was not the not yet identified celebrity A in the New York lawsuit. Busby warned that the only way to avoid a public spectacle was for Mr. Carter to provide his clients something of substance in settlement. Busby also threatened to pursue Mr. Carter for claims that Busby had not been identified on persons of behalf he did not represent. It has been my experience that when someone does this to a victim once, the likely is that they have done the same or similar things to others. Busby's accusations are categorically false. Declaration of Sean Carter. Oh, that's what he said in his declaration. But the extortion demands, combined with Busby's prior public threats, sent a clear message to Mr. Busby. I'm sorry, to Mr. Carter: pay up or face criminal charges and public condemnation. It's very interesting how he's not going to elaborate on the John Doe because also, eh, y'all hear me out. Y'all hear me out. Even it doesn't matter what side of the fence you're on. He only addressed, he said the Jane Doe extortion letter made clear that Carter supposedly was not yet identified celebrity A in the New York suit. Busby warned the only way to avoid a public spectacle. Here's the thing, he said that in both of the demand letters. So why aren't we discussing the John Doe demand letter? What happened to the John Doe demand letter? That needs to be what happened to John Doe? That needs to be a hashtag. That has to be a hashtag. Anywho's, the extortion demands came with a 2-week deadline, warning that if Mr. Carter failed to comply, defendants would take a different course. Mr. Carter understood from Busby's campaign of public threats combined with private demands for money that Busby would create a spectacle, including a criminal referral, if Mr. Carter did not buy his silence. I believe that that is a little bit of overreach, and this is my opinion. I never try to push my opinion on everybody, but people come here to listen to me and give my opinions. We hash it out in the comments. That's what I like about it. Here's the thing. One, the public threats was not directed to anybody. It was directed to those who are close to Combs. If you are making claims that you're not close to Combs, that you and Combs are not friends, why do you feel that it was a threat? Number two, the private demand letters did say something of substance, but that could have been information because they did sit down. What they did is they asked for a confidential meeting. That confidential meeting could have given information. Hell, it could have probably given more information in the Sean Combs case, not in just, you know what I'm saying? So I have to think about that. It wasn't all about money. The demand letters say, call my office. Let's set up a scheduled time to meet and speak because it probably didn't even like what I'm trying to say is the demand letters in which I draft, we actually demand money. We either say we need policy limits or we put a number on it. This demand letter did not state a number. It just asked for a confidential meeting. And I believe that the something of substance was more of information and not monetary. Mr. Carter understood from Busby's campaign and public threats combined with private demands for money that Busby would create a public spectacle, including a criminal referral if Mr. Carter did not buy his silence. After sending these letters to Mr. Carter privately, Busby intensified his media campaign with more threats of criminal prosecution. Around November 14th, in a film produced by TMZ, Busby threatened those who attended Combs' parties, calling them just as guilty, in which they are. If you attended a Diddy party and you seen these activities going on to men, women, and children, you are just as guilty. Anywho's, Busby said that some alleged victims of Combs had already spoken to the authorities and that he was encouraging all of his clients to do so. And so he should. Because isn't that what you said? That if it's really what it said it is, to go to the authorities instead of filing civil suits? When Mr. Carter refuses to be extorted, defendants defame him. Instead of caving to defendants' extortion, Mr. Carter filed a lawsuit anonymously on November 18th. Buzbee responded by publicly tying his prior media statements to Mr. Carter. In a flurry of social media posts, Buzbee branded Mr. Carter as a rapist. On November 18th, Buzbee posted on X that Jane Doe was a sexual assault survivor. The next day, Buzbee liked an X post suggesting that Mr. Carter was previously unnamed Celebrity A, who allegedly raped Jane Doe. In response to Mr. Carter's refusal to bend to extortion, Mr. Buzbee threatened on social media to publish the extortion demand. Since our professional efforts at resolution obviously have failed, we will instead disclose the demand letters. On December, I missed that one because, child, I was waiting on them. On December 8th, Busby amended the complaint in New York action to explicitly name Mr. Carter as the celebrity A who supposedly raped Jane Doe at the party in New York City in 2000. Now, word choice, supposedly. Now, for Jay-Z, you're going to put allegedly or supposedly, but for Diddy, yeah. On December 10th, Busby went even further in a statement to TMZ. Busby said he's not ruling out filing rape charges against Mr. Carter with New York authorities. Busby also said that Jay-Z's rape accuser might take the music mogul's advice and file a criminal complaint against him after slapping him with a civil suit. Just 5 days later, NBC News discredited Jane Doe's story and revealed that Busby had not investigated her claims. Chief among the deficiencies that NBC revealed was that, contrary to Jane Doe's allegations, her father had no memory of making the 10-hour round trip from Rochester to Manhattan to pick up his teenage daughter from the party. Defendants never spoke to him to corroborate her allegations, nor did they seek to confirm that the musician Benji Madden, with whom Jane Doe claims she spoke on the night of the alleged assault, was in attendance. Madden could not have been because he was performing in the Midwest that night. Instead of owning his failure to vet Jane Doe's claims, Busby pinned it on another law firm and suggested that his clients take a polygraph test, in which she did not do. Um, One, in the complaint, the amended complaint, she never mentioned Benji. Um, what else? With the NBC interview, in which I really, really, really hated that Busby allowed her to do this. Um, the NBC journalist also advised, like, even though they found some inconsistencies, that still doesn't take away from her story as to what actually happened to her. As far as vetting goes, he came out in his declaration in regards to the process that Jane Doe went through. I would like to know what John Doe went through. What was his process? Legal standard. California anti-SLAPP statute requires a two-step analysis. At step one, the defendant must establish that the challenge cause of action arose from protected activity under the statute. If the defendant meets this burden at step two, the court examines whether the plaintiff can make a prima facie showing of facts which, if credited by the tier of fact, would sustain a favorable judgment. At step two, courts considered neither the weight nor the credibility of plaintiff's evidence. The court accepts evidence favorable to the plaintiff as true and assesses the defendant evidence only to determine if it defeats plaintiff's case as a matter of law. So, the biggest thing with the declaration that the expert submitted, that was the thing. Was Busby's conduct in question? Was the demand letters, properly written? Did they violate any type of rule or statute? Um, and that is the argument that they're trying to make here. So, step one, defendant's extortionate conduct is unprotected. So, defendant's conduct is extortion as a matter of law. Defendants cannot meet the burden at step one. Their threats to publicly accuse Mr. Carter of being a child rapist, coupled with the public threats of criminal prosecution constitute extortion, which is unprotected speech. Extortion treats threats dressed up as pre-litigation demand letters are undeserving, oh my gosh, of the protection of the anti-SLAPP statute. Extortion is the act of obtaining money or property from another through the wrongful use of force of fear. Fear may be induced by a threat to accuse another of a crime or disgrace. Such a threat, when coupled with a demand for money, is a crime punishable in the same manner as if money or property were actually obtained. The threat of a criminal referral when linked to a monetary demand is extortion. Ah, but now we're getting back to the demand. Was there any money demanded? Was there any money demanded? That demand letter simply asked for a confidential meeting to come to some type of resolution. But as I stated to you guys before, that mediations does not always have to be in regards to money. Think about divorce cases. Sometimes it's just a mediation. We can sit down and have a mediation to figure out how we're going to do this child visitation. Look at Drake's case. All he wanted to do was pre-depositions to get more information to determine whether or not he needs to sue them for real. So every sit down does not necessarily mean they want money. And once again, this is my opinion. Everybody can feel the way that they want to feel. But I believe when Buzbee said something of substance, it was more on the lines of information. What information do you have on Diddy? Because that's the main guy that he's going after. Now, anybody who else is included, that's it. What else does it say? The threat need not to be overt. It is enough if the victim reasonably fears being accused of some crime. To determine if a threat is extortionate, court assesses the context of a demand, viewing the totality of the letter and the defendant's conduct leading up to the transmission. The context of Busbee's demand confirms their extortionate nature. Leading up to the extortion demands, Buzbee publicly vowed that the day will come when we will name names other than Sean Combs. He warned that his clients would speak to the FBI because they have some very important things to say. He threatened that I expect the Combs indictment and the charges in the indictment will grow. And he argued that people who were affiliated with Combs' misconduct should be prosecuted and put underneath the jail. In the lawsuit that Buzbee filed on behalf of Jane Doe, he shielded the name of Celebrity A, but accused that celebrity of grape. Shortly after making these public statements, defendant sent demand letters to Mr. Carter that accused him of having raped two minors, John and Jane Doe, and demanded that he pay something of substance or else defendants would take a different course. That different course included Busbee's threat to cause a public spectacle. In the context of Busbee's public threats to refer his targets to law enforcement and his private threats to hunt for other criminal acts involving parties unrelated to his clients, told Mr. Carter that he should fear a criminal prosecution. Buzbee continued his public criminal threats, promising to encourage all of his clients to speak to the authorities. These were threats to publicly accuse Mr. Carter of rape and to disclose criminal activity against victims who were not even Busbee's clients unless Mr. Carter paid his clients substantial sums. That is extortion and beyond the pale of permissible pre-litigation conduct. Confirming his extortive intent, Buzbee publicly revealed that Mr. Carter was the celebrity he had been referencing, going so far as to claim that he's not ruling out filing rape charges against Mr. Carter with the New York authorities. as soon as Mr. Carter refused to pay up. California courts consistently hold that such conduct is extortion, rejecting attempts by lawyers to extract settlements by cloaking unlawful conduct in legalese. And flatly, the plaintiff sued a lawyer, Morrow, for civil extortion arising from a demand letter Morrow sent to Flatley on behalf of a woman who claimed that Flatley had raped her, and on subsequent calls, Morano demanded payment to settle the woman's claims. Morrow argued that the letter was pre-litigation settlement offer and therefore protected. The California Supreme Court held that the letter was unprotected extortion. The key passage in Morrow's letter warned flatly that unless he settles, Morrow would expose information to the IRS and other authorities, uncover additional causes of action against Flatley once the lawsuit was filed, expose information to the media worldwide, and expose any violation by Flatley to the appropriate authorities. All right, I get it. And I bet you they're going to say, well, because Buzbee said, they want something of substance. And if they don't get that, they're going to make a public spectacle. Hmm. Morrow was also threatened to accuse Flatley of raping Morrow's clients unless Flatley paid for her silence. Buzbee did the same, threatening to one, expose Mr. Carter as a serial rapist in a public spectacle, uncover more victims of Mr. Carter's unspecified criminal misconduct unrelated to the Jane and John Doe claims, and three, encourage his clients to report Mr. Carter to law enforcement unless Mr. Carter paid something of substance. Keyword, I didn't see paid. I didn't say see where Busby specifically said that Mr. Carter um well, I need to go back because I could have sworn that they did say that he said that Mr. Carter was a rapist. But if not, then that wasn't in the demand letter though. Was it in the demand letter? These threats were criminal exposure and that Mr. Carter would be exposed to opprobrium and be disgraced thereby unless he met Busby's demands. Courts have followed flatly to reject anti-SLAPP protection for conduct far less egregious than Busby's threats here. In Mendoza versus Hamza, I think, an attorney threatened to report an opposing party to the district attorney and publicly disclose wrongdoings unless he settled. The court held that the lawyer's conduct was not protected because a threat to report criminal conduct to enforcement agencies, coupled with a demand for money, constitutes criminal extortion as a matter of law. Similarly, in Stanagem, the court held that a pre-litigation demand email was extortionate as a matter of law because it threatened to expose the defendant to federal authorities by alleged violations of law unless he negotiated a settlement. The defendant's email did not expressly threaten a criminal report or demand a specific sum of money. That's where I was getting at. So in this email, it didn't expressly threaten a criminal report or demand a specific sum of money. Nevertheless, viewing the totality of the email and the 6 months history leading up to its transmission, the court held that the plain implication of the email was a threat that unless the plaintiff agreed to some sort of settlement, the defendant would report him to the authorities. Okay, I see. That's why it's good to look at other cases to see how they were ruled in those cases. Hmm. The absence of either an express threat or a demand for a specific sum of money in the email did not negate its fundamental nature as an extortion writing. Okay, that makes sense. All right. So what Buzbee did, that was a form of extortion. In Falcon Brands, in that case, it says viewed in context, emails were extortion. Settle the case now, or a third party will become aware of your alleged criminal misconduct. In a footnote, defendants assert that their conduct does not qualify as extortion under Flatley, relying on Malin Singer and Flickerning Finwall. Nevertheless, neither case applies. In Malin, there was no threat to report the lawyer's target to the authorities. Similarly, in Flickinger, the attorney threatened only that his client would aggressively defend him in litigation. Buzbee's conduct was different. Buzbee threatened much more than a civil lawsuit. He threatened to expose Mr. Carter as a serial rapist in the public spectacle and have clients press criminal charges. His public threats of a criminal referral, coupled with their demands that Mr. Carter pay something of substance or else would take a different course, that would involve a public spectacle that establishes extortion as a matter of law. This makes sense now. Ooh. Mm. Defendants fail to show that John Doe demand is privileged. Defendants argue that Mr. Carter's extortion and intentional inflictions claims are barred by the litigation privilege. That argument fails. Courts determine whether a pre-litigation letter is protected under the anti-SLAPP law by assessing whether it has made in good faith contemplation of imminent litigation or as a hollow threat of litigation. Defendants must make a prima facie showing that they seriously and in good faith propose imminent access to the courts as the meaning of resolving their dispute. Let's see. As to the John Doe extortion demand letter, defendants cannot meet their burden. First, defendants fail to show that they intended in good faith to pursue litigation. The only evidence is Buzbee's self-serving declaration. My firm and two of our clients were prepared to assert civil claims against Carter. The letters were sent in serious good faith anticipation of litigation. Busbee's recitation of the good faith standard is not enough. When an attorney relies solely on his self serving declaration that, in his own mind at the time he submitted the claims, his mindset was that litigation would be necessary, this is insufficient to establish a prima facie showing. Huh. Second, defendants failed to show that they contemplated imminent access to the courts to resolve John Doe's accusations. Whether a lawsuit was ultimately brought is relevant, whether one was contemplated in good faith at the time of the demand letter. Defendants sent the John Doe extortion demand letter 3 months ago, but they never sued on his behalf. Their inaction exposes that the letter for what it is, hollow threat of litigation. Ooh. And they cited Dickerson versus Cosby. Bill Cosby's failure to sue after sending demand letters suggests that the demand letter was a bluff intended to frighten the recipients into silence. Baby, we getting somewhere. We're getting somewhere. So what they're saying is because they didn't sue, that it was just a bluff. They really didn't have no evidence against him, even though that they said they had evidence. Mm, Child. I don't know this. I don't be trying to poke the bear or the beehive. Finally, defendants failed to show that they sent the John Doe extortion demand to achieve the objections of litigation. Instead, defendants resort to obfuscation. They claim to have sent the extortion demand in anticipation and serious contemplation of litigation, which has now been filed, and that the accusations in the John Doe extortion demand letter directly relate to the allegations in the Jane Doe's lawsuit. That is false. No lawsuit has been filed by John Doe, and John Doe's accusation concern events that occurred 15 years after those issued in Jane Doe's lawsuit. That does not satisfy defendant's burden. Oh, this is interesting. Number two, step two, Mr. Carter will prevail on the merits. If defendants meet their burden at step one, Mr. Carter must show up at step two that his claims have minimal merit. And they do. The litigation privilege does not apply to defendant's conduct. The litigation privilege is an affirmative defense that defendants must prove it applies. In Palmer versus Zach Lama, a court may grant an anti-SLAPP motion based on the litigation privilege only if the defendant defeats the plaintiff's evidence as a matter of law. Defendants cannot meet that burden because they bear the burden of proof. They have to prove. As established above, defendants failed to make even a prima facie showing that the John Doe extortion letter or demand letter was a good faith pre-litigation demand. Courts routinely deny anti-SLAPP motions, whereas here the defendant fails to show the litigation privilege applies as a matter of law. Mr. Carter will prevail on the merits of his extortion claim. As established in Section 1A, defendants committed extortion as a matter of law. Mr. Carter has therefore exceeded the minimal merit threshold to defeat defendant's motion. Defendants argue that Mr. Carter claims fails because he did not lose any property. That is, he stood up to the extortion and he cannot allege the falsity elements of fraud. By these arguments are foreclosed by Flatley, which requires neither of transfer of property nor the defendant's threats are false. I mean, sometimes this just sounds crazy. Mr. Carter has met his burden on each element of his defamation claim. The defendant's statements are of and concerning Mr. Carter. To be defamatory, a statement must be of and concerning the plaintiff. Defendants do not dispute that their December 10th statements on TMZ meets the test. They argue that their October and November statements do not. That is wrong. Whether a statement is of and concerning a plaintiff is for the tier of fact. Courts consider the totality of the circumstances, including the nature and full extent of the communications and how the attended audience would interpret them. A statement need not name the plaintiff if it refers to a group to which the plaintiff belongs, if the group is sufficiently small and its members easily ascertainable. The question is whether the publication points to the plaintiffs by description or circumstances tending to identify him. Dickerson, too, deposes of Buzbee's argument. Dickerson was one of many women who publicly accused Bill Cosby of sexual misconduct. She sued for defamation based on Cosby's statements, some of which mentioned her name, some of which did not. The court held that the latter statements were nonetheless actionable. The statements referred to members as of a reasonably a certain group of women who had recently accused Cosby of sexual misconduct, of which Dickerson was a known member. Given Buzbee's extensive media crusade, his defamatory statements were reasonably understood by his audience to refer to Mr. Carter. Mr. Carter is one of only two people who Buzbee had publicly accused of rape. And on November 19th, Buzbee confirmed that his public statements had referred to Mr. Carter. Buzbee liked an ex-user's post that identified Mr. Carter as Celebrity A in Jane Doe's complaint. On December 10th, Buzbee publicly accused Mr. Carter of rape by name. It is no defense that Buzbee's statements identifying Mr. Carter were made subsequent to those that do not identify him. Man, defendant's statements are defamatory per se. Defendant's false statements are defamatory per se because they accuse Mr. Carter of committing crimes of moral turpitude. Such accusations are defamatory on their face as they expose Mr. Carter to public hatred, contempt, ridicule, and disgrace. Statements that falsely impute criminal conduct are defamation per se. In such cases, general damages are presumed and causation is established by defamatory nature of the statements alone. Um, Defendant statements are false assertions of fact, not opinion. Defendant's arguments that the statements are non-actionable opinions is incorrect. The key question is not the gloss someone later put on their statement, but whether a reasonable fact finder could conclude that the statement declares or implies a provably false assertion of fact. Busbee's statements in the First Amendment complaint falsely declare or imply that Mr. Carter committed crimes, making them actionable. Courts assess falsity based on the totality of the circumstances, including 1, the language used and whether it conveys a defamatory meaning, 2, the context in which it was made. Viewed in context, each of Busbee's statements contain factual assertions that are reasonably understood in a defamatory sense. Busbee told TMZ that he's not ruling out filing grape charges against Mr. Carter with New York authorities. And each of the defamatory statements asserts the same, or that Mr. Carter committed related criminal acts. Buzbee asserted that Mr. Carter, 1, facilitated actual misconduct, 2, should be prosecuted and put underneath the jail, 3, is among the people on the long list of names who are going to be named in the cases alleging actual misconduct, and D, committed actual assault, which Jane Doe is a actual assault survivor. These are not opinions because they can be proven true or false. Mm. Finally, Mr. Carter presents evidence of falsity. He denies the accusations in a sworn declaration. The deficiencies that NBC News exposed in Jane Doe's narrative further evidence the falsity of Busbee's assertions. Defendant defamed Mr. Carter with actual constitutional malice. To show actual malice, Mr. Carter must establish a reasonable probability that he will produce clear and convincing evidence at trial that defendants either knew their statements was false or acted with disregard of the truth. Defendants wrongly assert that proving actual malice requires direct evidence. However, actual malice can be proved by circumstantial evidence. Even if Busbee didn't know his statements that Mr. Carter raped 2 people were false, he nonetheless acted in reckless disregard for whether that was true. Circumstantial evidence of actual malice can include evidence of motive, failure to adhere to professional standards, reliance upon sources known to be unreliable to known to be biased against the plaintiff, and failure to investigate before making a statement. Defendant Tony Buzbee has failed at each of those. Defendants had professional and legal duties to investigate Jane Doe's claims before accusing Mr. Carter of rape. The same is true in New York, where Buzbee filed the Jane Doe lawsuit. As Mr. Carter, expert on attorney ethics, Mary Baldwin, explains in her declaration, when Mr. Buzbee accused Mr. Carter of child rape, an extraordinarily serious charge, he had not fulfilled his professional obligations to investigate the facts. It necessarily follows that when Buzbee stated publicly that Mr. Carter was a rapist, he was at best speaking recklessly. That is further evidenced by Busbee's awareness that his client's 24-year-old claim was hard to corroborate, that he had relied on another firm to vet the claim, and that before he accused Mr. Carter of raping his client, he had never even met her. No one verified key details, yet defendants relied solely on her story to the exclusion of other sources. That includes not speaking to the father, who she alleges picked her up after the alleged rape in the early hours of the morning at the gas station. Had Busbee done so, as NBC News did before accusing Mr. Carter, he would have known that he could not recall a 10-hour round trip driven to pick up his 13-year-old daughter unless under these circumstances. A key fact that he says that he, like any other parent, would remember. Nor did Busby verify the identity of the celebrities. Jane Doe claimed to have met at the party, or whether Benji Madden, who she claims to have spoken with, was even in New York. A Google search reveals that he was 800 miles away in Chicago. Now, why these questions weren't brought up, I don't know. I don't know. Busby did drop the ball on that. But he did say that she went through a very severe vetting process in his declaration. Busby's conduct demonstrates willful blindness and a reckless disregard for the falsity of the accusations. Um, Mr. Carter is entitled to special damages. Defendant claims that their statements not even mention Carter and that he has not pled special damages is false. Their December 10th statements names Mr. Carter, and though he need not prove special damages to prevail, Mr. Carter can do so by showing the harm that the defendant caused to his business and reputation. Mr. Carter viewed Busby's defamation as a what he says, existential threat to his career and to his company, Rock Nation. Busby's public statements immediately caused Mr. Carter and Rock Nation to lose contracts in the sports and entertainment space that would have generated approximately $20 million in revenue annually. They would cause media sources to speculate that Rock Nation would lose contracts and other businesses, causing one such business to publicly address the impact of these false accusations. And Mr. Carter faces economic harm from the damage to his reputation, lost business partnerships, and tainted reputation established special damages. Now, my question is, what businesses, like he was there at the Super Bowl. I didn't see that he lost any of his, businesses that he had. So once again, he will have to prove that he lost money. He lost contracts. He's definitely going to have to prove that. Not saying that he didn't, but from what I've seen, and everything be on the news, I haven't seen that yet. I haven't seen that yet. Mr. Carter will prevail on his emotional distress claim. Defendant argued that falsely accusing Mr. Carter of raping two minors is not outrageous. And you know what? Going back to lose contracts in the sports and entertainment that would have generated approximately 20 million. Okay, well, we're going to see. Defendants argue that falsely accusing Mr. Carter of raping two minors is not outrageous. That appalling assertion is contrary to the law. Conduct is outrageous when it exceeds all bounds of that usually tolerated in a civilized community. Falsely accusing an individual of child molestation is extreme and outrageous conduct. The cases, the cases defendants cite do not hold otherwise. They cite no authority that the false accusation of serial child rape is anything less than extreme and outrageous. Nor is it correct that Mr. Carter cannot show severe distress. The public spectacle that defendants threatened and then created has caused Mr. Carter to suffer mental anguish. Given the knowledge that Buzbee is trying to maliciously destroy him, his livelihood, and his family, and continue to feel the mental anguish about the ticking time bomb that Buzbee planted. This is more than sufficient. In conclusion, for the reasons the court should deny Tony Buzbee's motion to strike Jay-Z's amended complaint for extortion, defamation, and intentional infliction of emotional distress. Who? Now, hopefully, that makes now what I read yesterday, that should make sense as Jay-Z's account, his declaration, as well as the expert's declaration of how Tony Buzbee's conduct is considered unlawful, unethical, and the whole nine yards. So, overall, That is Jay-Z's opposition as to why the judge should not strike Jay-Z's First Amendment complaint. I hope that made sense. If you guys have any questions, please, please, please leave them in the comments below. Once again, this opposition was filed on February 10th. The Jane Doe case was filed, or was voluntarily dismissed, I should say, on February 14th. So this is a lawsuit involving Jay-Z and Buzbee that was initially filed back in November. So this is not a new lawsuit. This is nothing has been amended to say this is how much they're asking for, right? They're just telling us what Jay-Z has lost thus far. There's no specific number. All we seen was the 20 million annually. That's it. That's all. All right. But y'all tell me what y'all think about this in the comments below. Definitely do not forget to like, share, and subscribe. Until then, you all have a blessed night, and I'm out. Bye.